All right, you good.
Islam, brothers and sisters, I'm back again. As we clearly stated that we understand that we have a long history that's rich, and they were trying to preserve it, and this is why the Bible was written by King James, to inform us that we do have a protection from our ancestors who see themselves as lords and gods. So now we're going to see that the story was covered up by Norman French, by William the Conqueror, and we were given a new identity as so-called Jews, which the so-called Jews who say they're Jews are not. They're Germans. We're the true Jews, the one who's written right in the Bible, but we just went by a different name, which is the misnomer. But in reference to the misnomer, it clearly says here that history of the Jews in England. The history of the Jews in England goes back to the reign of William the Conqueror. The first written, did you hear that? I brought this to your attention last time. It says the first written record of Jewish settlement in England dates from 1070. So how could there be a Jews BC when the very first record of so-called Jews, which is based off English, not Hebrew, not whatever other one you want to use, it says was written, recorded of Jewish settlement in England dated from 1066. The Jewish settlement continued until King Edward I and the Edicts of Expulsion in 1290. So now the Statute of Westminster was written in 1285. That's 4 years later, they were expelled. So now the Statute of Westminster has the clause done its conditionalibus, which means that the land cannot be transferred, but no other persons but the heirs, i.e. English, Anglo-Saxon, Corsican, Berbers. We already proved it. Maurice or Mauritius were terms of the invaders who are actually identified, or should be identified, as Berbers. That history goes back to the 22nd dynasty, 943 BC, even before that. Because there was only 26 dynasty of Berbers before the stories were revamped by some people calling Greeks Romans, which has no history or date or record because their calendar in which they used to support their story was not created until 1582 by Pope Gregory XIII. I don't know what else to say to you, brothers and sisters, but check this out. It says that the Jewish settlement continued until King Edward I edict expulsion in 1290. After the expulsion, there were no Jewish communities apart from the individuals who practiced Judaism secretly until the rule of Oliver Cromwell. While Cromwell never officially readmitted the Jews to the Commonwealth of England, a small colony of Sephardic Jews, these are the Arkansas Jews, that's not us. We were not allowed to come back. Let's prove this. Let's go to Norman, England, 1066. Status and standing. Status and standing as English, Anglo-Saxon, Corsican, Berbers.
Do you hear this, family? Do you hear this?
Was under the strict jurisdiction of the king.
So all the family who don't think as of right now that there is a such thing as status, family, even this is telling you right here in lieu of status of so-called Jews. It's showing you right here that status does, it is applicable. So family, to all the family Moors who don't believe in status in lieu of your proper status and standing. Here it is right here, family. So you don't believe that status and law in lieu of you connecting yourself back to the land, family. It's right here, family. It's right here. The English Grand Sheik is dropping it right now. He's dropping the facts to you. Go ahead, finish up.
Oh, I'm about to get real deep now, brother. Status of the Jews. Prior to their expulsion in 1290, the status of the Jews in England were completely dependent on the will of the crown. So now, who was ruling England prior to William the Conqueror? King of England. This brother. And the last kingdom, or the last descendant of this brother, was Edward the Confessor. He created what they call the Great Silurium, where New Jersey get their derived authority from. Because if you check out case law, Credit River case, First National Bank versus Jerome Daly, it clearly stated that the Constitution of the United States from 1776 and any amended Constitution authority derives, as well as the Bill of Rights, get their authority from the Magna Carta, which was signed by who? John II. John I in 1215, who was the son of Henry II, who was the son of Geoffery V from the House of Plantagenet, or the House of Angevin, or the House of Anjou, that goes all the way back till 57 AD, known as the Endicavy, when it was called Amorica. Amorica. Let's go a little further. It says that they was under the will of the crown. English Jews were legally under the jurisdiction of the king, who offered them protection in return for their economic functions. As royal serfs, there were allowed freedom of the king's highways, right to travel, more, right to travel, exemptions from tolls, no taxation.
You hear that, family? Exemption from tolls, family. So you see where we get this authority from, family? Oh, wow, this is beautiful. This is beautiful. I don't see nobody else like this English Grand Sheik right here dropping this.
I'm going to drop some more. The ability to hold land directly from the king and physical protection and physical protection and the vast network of royal castles built to assert Norman authority. So we have protection pertaining to holding the land. But in order for you to hold land, you must be in your proper status. We're talking about status, right? You must be an English noble.
You hear that, families? This is beautiful.
He said, don't throw away your slave names, i.e. your English surnames, your family names. Why? Because they're linked to your birthright, i.e. your estate, i.e. your property. Real property, not under fee and simple. They did away with that under common recovery by way of establishing case law, which is unprecedented. It's not backed by stereotypes, common law, under the Commonwealth of the laws that gave authority to the United States under the jurisdiction by way of the Treaty of 1783, signed on September 3rd, ratified January the 14th, 1784, by Thomas Jefferson. How did Thomas Jefferson get that last name Jefferson? Because his last name was Skelton and Randolph. That's his descent name. His great-great-great-grandfather, the 19th, was Edward the Confessor. Was William the Conqueror. His 19th grandfather was, his son, Henry I. One of the two, Henry I or William the Conqueror, was the 19th grandfather of Thomas Jefferson, who was not a Jefferson, because he don't look like this. This was King Edgar the Peaceful, i.e. King Edgar Jefferson, or King Edgar Godfrey. Son is a prefix, means descended down from. Frey means Lord Master, and Geo means earth. Lords of the earth. It's right there. Etymology. You gotta look it up, Morris. Let's go a little more. It says the clause, it says, this was resorted to, let's talk about this. The Jews of London was the responsibility of the constable of the tower, and for this reason, they were able to seek refuge in the Tower of London. Let's go down a little further here. It says, going to the bottom of that paragraph, there are records of the body of Jewish men at arms forming part of the garrison of the tower in 1267 during the Civil War. The clause to that effect was inserted under Henry I, because remember, Henry I was the son of William the Conqueror, and they swore to uphold the laws of Wittemont. But they changed it to Roman Curia. You hear Taj talk about that a lot, the Roman Curia. They switched from the Wittemont to the Roman Curia because they instituted the feudal system under common recovery to grant land by way of quiet rent to those, i.e. vassals of the minor, i.e. king, and they was the actual tenants. But they switched places with the so-called Jews, and now they made us tenants.
Ain't that something?
They tax you.
So basically, family, with the English Grand Sheik saying that you're the real flesh and blood landlords. They switched your status and made you a tenant, made you, i.e. a renter, made you a tax-paying rent payer. So, family, we got to start taking this back because, again, the English Grand Sheik, he's giving some explosive information. Not only just that, he's living it. He's showing it right now. He's showing it in the courts right now. These i.e. magistrates, they're scared to death of the information that he's bringing in. Not only just that, he's proving it. He's showing it right here today. We're going to show you the information and bring you that information and just show you proof that he's living it. He's doing it himself. See, a lot of Moors, they talk about it and throw out these affidavits and things that like that, and throw them into these courts or whatever, but no one's stepping foot in honoring those affidavits. No one is sitting there doing what we are doing right now. No one's doing this. No one's doing it. They claim they are, but I don't see more people that's actually stepping out and paying rents. But yet they're changing the nature and status, showing that no, I am the landlord. I am the overlord here. This is my property, my land, and you I'm gonna cease for you holding me heist as a renter here on my property.
Islam. And this is going to qualify because it says the clause to the effect was inserted under Henry I in some manuscript of the so-called Legis Edwardus Confessor, which means the laws of Edward the Confessor. Let's type that. The title Legis Edwardus Confessor, or Laws of Edward the Confessor, refers to the English collective of 39 laws purporting to date back to the time of Edward the Confessor, ranging from 1042 to 1066. But did not appear in written form until the reign of King Stephen in the 12th century. Background. The Legis Edwardus served the purpose of legitimizing the legacy of William the Legis Edwardus served the purpose of legitimizing the legacy of William the Conqueror's rule and distancing the 12th century ruling class of England from their violent origins as conquerors. The treaty is believed to have been written sometime between 1130 and 1139, toward the end of Henry I's reign. Historians believe that the treaty is intended to recast Norman institutions as having Anglo-Saxon origin, but they don't. Okay, because why? Because William the Conqueror established what they call the, let's go here first. It says the Lega Edwardus is not a single law code, but rather a descriptive term meaning the laws and customs of England that were observed prior to the Norman conquest. So he ain't nothing to do with this. English bishops like Dunstan and Wolfston wrote the laws of Ager and Esthwaite Unready. Who is Ager? This brother right here, who looks just like me, who got my last name. Edward Esthwaite Unready was his son. All right? So now, he established what they call the Great Silarim. Let's see what the Great Silarim is. The Great Silarim. This is to give you both. I'm going to give you that one. I'll give you this one, but I'm going to tap this so that it can be a little clearer. It says the Great Silarim, or the Great Seal of the United Kingdom of Great Britain and Northern Ireland, known prior to the Treaty of Union of 1707. So now, how long did the Kingdom of England rule? From 927 to 1707, and that was authenticated by what? The Great Silarim, i.e. charter, by a land patent given by Edward the Confessor. And who was under the jurisdiction of Edward the Confessor? All the Jews. All those Jews were expelled from England, what year? 1290. By who? Edward I. Why? Because they was transferred under concession agreement to what they call corporations and what they call the Statutes of Mortemain. Statutes of Mortemain means dead hands. A corporation is dead. It cannot operate outside of the natural person who created it. So we have to understand that we are not legal fictions. Legal fictions were created by recovery, which was done by attorneys with the assistance of judges, clerks, and every other agency who works under authority by way of their procedural law established for their obligation to uphold the rights of the people. They're not doing that. Why? Because they're agents. They are foreign agents. They waive their nationality. See Article 4 of the United States Code 1481, which says that if you work for a foreign capacity, you waive your nationality. If you waive your nationality, you're not an English noble anymore. So that means you represent a foreign capacity, a foreign agent, which is a violation of the law. So you have to file a foreign agent registration statement. What do corporations have to file? A certificate of registration with the Superior Court. We as natural people, when we proclaim our national name, we file with the county, i.e. shire, two separate jurisdictions. Why? Because the Superior Court deals with chancery equity. Equity is fairness. That goes back to the time of what they call the common law, which was created under the, look it up, Clifford N., my first name. Okay, I want you to see something else. It says, on the Treaty Union of 1707, as the Great Seal of Great Britain, the Great Seal of Ireland, from the Union of 1801, as the Great Seal of the United Kingdom of Great Britain and Ireland. It is the seal that is used to symbolize the sovereign approval of important states' documents. Scotland had their own Great Seal since 14th century, the Act of Union 1707. Joining the Kingdom of Scotland and England provided the use of the Great Seal for the United Kingdom. Let's just go down a little further. It says that sealing wax is melted in a metal molded or matrix and impressed into a wax fixture that is attached by a cord or ribbon to document that the monarch wishes to make official. The former keeper of the seal is the Lord High Chancellor. Chancery Court. Equity. It has to be a seal. All documents by way of affidavit pursuant to the Fourth Amendment must be signed and sealed with an embossed seal. It must be raised.
Do you hear that, family? It's what I've been teaching. That you must have, you go take a look at all my videos. You'll see that I keep saying that they have to be signed under signature and seal. Same thing. Okay. That's where that stuff come from. Straight out of England. It's showing this stuff.
Let's go ahead now.
This signature and seal stuff. I showed it in the in one of my other videos as well. Several of them.
Let's show this.
It says that it came from England and moved towards Britain. Britain.
History. I hope y'all ready for this one. Is y'all ready for this? I don't think y'all. This is the so-called seal of the incorporated state of New Jersey. New Jersey was incorporated in 1640 by Charles II, who issued a charter out to George Carteret and Mr. Berkeley, whatever his first name is. In 1640, he issued what they call the concession agreement under what they call quiring. This is when East Jersey and West Jersey had their own constitution. But in 1702, Queen Anne issued the first governor. His name was Viscount Cornbury. And he said that the legislature for New Jersey should have a fusion of government overlapping, and that was under the jurisdiction of the King of England, because Queen Anne ruled in passed it to King George in 1714. Because remember, the King of England moved from what? 927 to 1706. So now it was still under the jurisdiction of King England. This is why New Jersey is called Belwick of Jersey, under the jurisdiction of England. Let's prove this. It says, what's so great about New Jersey Great Seal? The concept of a state seal dates as far back as ancient Mesopotamia, when officials were rolled engraved cylinders on wave clacks to mark documents. We just read about it. The Great Seal of Rim. On clay, on wet clay. You good? You good?
Good. You good? Good.
On wet clay to mark documents. From ancient Egyptian pharaohs, i.e. Berber pharaohs, to the 18th century, European monarchs and ecclesiastical officials, metal stamps and signet rings were used to imprint their emblems into wax as proof that a document was authentic and carried their authority. Wax seals were also used by ordinary people on folded letters as security against prying eyes. A letter could not be opened without breaking the seal. Seals are often found in many cultures around the world. Listen, Morris, Americans inherited their practice from Europe, specifically from England, where the Great Seal of Rome was used to symbolize the monarch's authority. Forgery was a capital offense during the English Civil Law. When James II attempted to flee from France in 1688, he threw the Great Seal into the Thames River so it could not be captured and used by his enemy. Did you hear that? King James threw the seal into the Thames River so it could not be captured by his enemy. Who? France. French. Louis VIII all the way up to Louis XVI. Louis XVI was beheaded. The purchase of Louisiana, why do you think they call it Louisiana? From St. Louis. He purchased Louisiana, purchased from who? Napoleon. Louis VIII grew up in what? The Anglo-Saxon courts. This is when you get into what they call the Capitan and Patrician Wars by Louis XIV, Louis VIII's son, whose name was Saint Philip of Augustus. Look it up. Saint Philip of Augustus, whose father was Louis VIII, grew up in the Anglo-Saxon courts. Okay. New Jersey and the Great Seal of the United States of America. With the ideal of a seal of state already part of the culture, it isn't surprising that the practice was adopted by the United States. Indeed, it was considered so important that when Congress declared independence from the Great Britain on July 4th, 1776, they also named the first committee to design a seal the same day. It was comprised of Benjamin Franklin, Thomas Jefferson, and John Adams. As brilliant as three men might have been, they were somewhat clueless when it came to matters of heraldry. Clueless, because they were not heirs. How you know that? Look up the Corsican. You'll see that it has the flag of England, and the Kingdom of England ruled what? From 927 to 1706. You have that white flag with the cross on it, with 4 Moors in each quadrant. And each of the Moor, Asiatic, Berber, Corsican, had a bandana around his head, which is one of the so-called symbols of what? Jews. Jews, Moors. So now, we already read credit versus revocation pertaining to the Constitution rooted in the Bill of Rights is rooted in the Magna Carta, signed by Geoffery the fifth Count of Anjou, great-grandson, John I. So now, a lot of people still might think that they don't believe it. So I'm going to show you in real life, real time, that who I am from the house of Geoffery, i.e. Jefferson, from the house of Pleasant, Angevin, or Anjou, whatever term you want to use, that the courts has recognized and will recognize any person who correct their status as English noble and know the history of themselves as English nobles, because this is where law is rooted in. They are the trustees. They are the trustees on behalf of the beneficiary. What happens? The beneficiary passes on the actual land to the trustees, i.e. the so-called courts, because all land is given by way of certificate of registration to corporations. They are the borrowers, and any income created by them is on behalf of the beneficiary. It belongs to you. Look up the gap. You understand what that is? That's called the General Accepted Accountable Principles, which states that they are obligated to credit your account because all notes, i.e. promissory notes, create an asset, which created an asset creates a liability. What liability? Because there was no promissory note created, i.e. IOU, until you gave your credit by your way of your signature on any instrument. So you have to argue that the instruments and what they created to justify what they're doing is a violation, because why? It's illegal. United States Code 3-306, 3-305, meaning that you have the right to argue any instrument that's illegal. And 3-306 means that if it was actually created in your infancy, and you didn't give the ability to be able to argue the fact because you were unconscious about it. But now you're not. The truth has been brought to the light.
Facts.
Now, these are facts, Morris. So now let's go into the actual proof of my argument. First, I'm going to give you Legislative Bill 3823.
It's facts. Check it out, Moors. It's over here in Jersey territory.
Yes, sir.
You see it for yourself.
Assembly Bill number 3823, State Legislative 210, legislated by John Matt Ahern, District 38. District 38, Moors. Do you know who your local senator is or your assemblyman? In New Jersey is what's the name? Assemblyman is Robert Clifton and Robert Dancer, and your they are assemblyman. Your senator is Samuel Thomas. These are the people who you have to go to. I actually have a meeting set up with them this month, matter of fact. They just didn't do it through the time of election and because of the holidays, so they're going to set up for not this month, but next month, so that I can meet with them in regards to this legislative bill, which clearly states that, or this act, which really clearly states limited to corporate powers and concerns of corporate responsibilities. An act concerning New Jersey's corporations amending the New Jersey Statute 1482-1. Let's go to it more. What does it say? It says, an amended and be enacted by the Senate and General Assembly of the State of New Jersey. Now we know that the first Senate or General Assembly was established by New Jersey State Legislature, which was established by who? First Governor Viscount Cornbury by who? Queen Anne. So the Constitution of 1776 created the Constitution of 1947, of which the New Jersey State operates under. And even the courts operated under New Jersey amended Constitution of 1947. So this legislative bill clearly stipulates that proposed purposes. A corporation may be organized under this act for any lawful business purpose or purposes except to do in this state any business for which organization is permitted under any other statute of the state unless such statute permits organizations under this act. Provided, however, that no corporation shall be deemed a natural person or a citizen for the purposes of either state or federal constitutional law. And the legislator and the governor reserves the power to impose laws, restrictions, regulations, responsibilities, and limitations upon corporations that may not be imposed upon natural persons. So the governor has the authority to regulate corporations. So if you're a corporation, they can regulate you. But according to the legislative bill, natural people are not supposed to be regulated by that which regulates corporations, i.e. statute, ordinance, codes, and so on and so forth. Because the Constitution don't give any rights, it only protects rights. But the Constitution was rooted in what? The Magna Carta. So you must first, because it don't protect rights, give you rights, it only protect rights. What rights? The rights as English nobles, English nationals.
You hear that, family? Do y'all hear that? Y'all have to be in a proper status as English nationals. English nationals. Taking it back. Connecting yourself back to the land.
Islam. Are you ready for this, noble?
Now check this out, family. This is what the English noble Grand Sheik, Clifford Jefferson L. Bay, from the House of Geoffery. Now check this out.
Okay.
This is what we doing in these courts right here.
As you can see here,
it's very powerful.
Superior Court, New Jersey. These are lawyers. Aaron versus Sturps. Landlord tenant, Woodhaven Terrace, limited liability claim. So I'm gonna let you know, Brother Syed Bey attended me in the hearing in regards to so-called non-payment of a debt. And brothers and sisters, I stopped the court. Shut it down.
True story.
According to the rules of the court, pay attention. When you go there, they have a camera clearly stating from the actual judge that if you have to pay the court, make a check out to the Department of Treasury. It didn't say to the Superior Court. It said to the Department of Treasury. Why? Because according to the Constitution, Article 1, Section 10, the only legal tending is gold and silver for paying debts. But the Department of Treasury do have the ability to create legal tender. They're not supposed to, but unfortunately they do. So if so-called party is claiming you owe a debt that can't be paid because you can't pay a debt, but it's a debt. So in the court, when we swore for the record, I let the court know that the only one who has the right to subrogation is the one who has the right to subrogation is the beneficiary, or insurance company, or tax rebate. That's the only way you can collect on the debt. So now, the only person that appeared in court was me, because the landlord didn't show up. It was the property manager. So I asked the court, I said the only one who has the right to subrogation is either an insurance company or by a tax write-off. And I said, and they don't do that to the end of the year. So now, if she's an insurance company, she has to say so for the record. She was not. So I said, well, how can she collect on the debt when she's not an insurance company? And so she must be the beneficiary, i.e. the landlord. She was not. Because I clearly stated for the record, how could she have the right to subrogation when she's not the landlord? She stated for the record that she was the property manager. So the judge tried to cover for him. So he said, so Mr. L. Bay, you mean to tell me that if I get a loan from the bank, I ain't got to pay it back? I said, no. He said, why? I said, because according to the Banking Act, Article 27, it says banks cannot make money or create money or sign their signature. Because Federal Reserve notes, you can't sign a signature because they're created from thin air by way of your signature, because prior to that, they did not exist. You created the Federal Reserve note, which is a debt, which creates assets, which creates a liability based on the IOU that was created from your signature. So I told him that banks could create money. He did not respond or say anything. So he said, so who is the landlord then? I told him, I am.
True story. True story, family.
I said, I'm the landlord. He did not object. The attorney did not object, nor did the property manager object. The judge got up and left to the chamber.
Walked out of the court.
Walked out of the court. He came back an hour.
An hour later, holding up the court. It was at least 30, 40 attorneys sitting in there to represent their own clients. And one of the attorneys leaned back towards me and stated, the validity in regards to your grand Sheik, the way he's speaking, it must hold truth, because he got us all sitting here for a whole hour, and it must be busting his brain in lieu of what the grand Sheik is saying that's on that piece of paper. Now, everything that the grand Sheik family stated for the record in this lecture, in this video, is right there on that paperwork. The same thing that this lecture was about is on that paperwork, and it was back there busting that judge in his head. He didn't know what to do or what to say.
Mm-hmm. And it's supported by affidavit. So the judge came back an hour later, and he quoted some of the affidavit. And he said, Mr. Elbay did some extensive research, apparently. He quoted some case law, blase, blase. And then he said, oh, I forgot something. He said, well, apparently Social Security does not accept discharge. So I'm like, oh, I never said anything about Social Security. Checks ought to be made to the Department of Treasury. So he said, you don't like my decision to appeal it. So I said, well, what is your decision? Because he got up. I said, because if you mention the word appealing, you must go to rule in favor of somebody. So he said, I'll give you my record silently. He said, I'll write it down.
I'll write it down on paper.
On paper. I said, no, this has to be on the record. He said, I'll write it down for you on paper.
So what he did was he already had the record shut off.
Shut it off. So when he came back, he just handed me the actual instrument, i.e. his order. First of all, New Jersey Rules 16A2-1 and -2, it clearly says that ministerial records must be on the record and must be signed by the clerk. It must be signed by a clerk with the seal embossed. So when he brought the actual instrument back, because remember, all arguments pertaining to parties must be on the record, the minutes, as well as his order and decision must be on the record backed by affidavit to support his ruling or order signed and sealed by the clerk. He did none of the two. He cut the record off, handed me his order silently, and told me, you don't like my decision, file an appeal. So to me, you should have seen how the so-called plaintiff attorney ran out of the courtroom. So my assistant back there reading the court order, And the judge gave me remedy.
Yes,
He said that apparently Mr. Elbey, he said some a bunch of other stuff, but his last quote was that Social Security does not accept negotiable instruments in lieu of discharge. So to me and my assistant Grand Sheik saying, we never said anything about Social Security. So what the judge did was give me remedy. He didn't state it on the record, but he had to give me remedy. Why? Because he know that there is no way you can pay a debt with a debt.
Mm-hmm.
So what I did is I went home, because what I did initially paying the actual party, I wrote an acceptance for value their instrument, i.e. coupon, which is also an instrument and it can be used according to Uniform Commercial Code 3-603. Failure to accept this instrument in lieu of acceptance is automatic discharge. So he apparently didn't want to accept that instrument, which was filed for the record. I filled out the proper 1099 form by Internal Revenue Service and sent him a copy, which was actually cast out because the insurance company, i.e. Middlesex Management, didn't say anything. Remember, I told you the only person who collected debt is the insurance company. They never sued me. It was Woodhaven Terrace, the so-called landlord, suing me. So I told the judge they been paid already. Why is the insurance company suing me, but the landlord coming to sue me? Shows you fraud. So what I did is I went home and wrote another, because we clearly asked the attorney in the hallway through mediation, what are you asking them? What are you requesting in lieu of payment? Are you talking about Federal Reserve notes? He didn't say nothing. He said no. I said, what, a check? He said, that'll work. I said, no, but you want a check in lieu of Federal Reserve notes. He didn't say nothing. So we get in the courtroom. I told the judge that, look, Your Honor, we already expressed to the attorney that what instrument are you looking for? What type of species are you requiring for us to pay this debt? We asked him Federal Reserve notes. He said no. So therefore, the instrument in lieu of the coupon was acceptable value. He didn't accept that, and then he had the laws to support that. So I said, I'm going to do even better. I'm going to write a check. A check is considered a bill of exchange, i.e. a letter of credit that's created by banks, because banks only do one thing, deposit on behalf of the public, and which creates credit. They're a go-between, because banks can't make money. Article, Banking Act, Article 27.
The people make money.
People make money by way of your signature, i.e. credit, because the House Joint Resolution 192, created in 1933, says that there is no money. So if you want to get paid, go to the Department of Treasury. That's the only department that creates legal tender, i.e. Federal Reserve notes. Because I ain't got no money. I ain't got no gold and silver. So the debt had to be discharged. There must be consideration. So therefore, I wrote a check out to the actual landlord. I sent it directly to the Department of Treasury. When I sent the Department of Treasury, I also sent a copy of the actual check, the actual 1099 form, as well as the actual affidavit support how to actually discharge it in lieu of the Department of Treasury. I actually sent a copy to the actual court. So now, what the clerk did, because the clerk is an attorney as well, you know that. Her last name is Esquire. So they issue out a warrant for removal. After the judge issue a judgment of possession, they now have to apply for what they call a warrant of removal. My argument is that the judgment of possession was not actually on the record, nor was it signed and sealed by the clerk. So I wrote a motion, attached an affidavit, in support of my argument, letting the judge know, according to the New Jersey Revised statute, that any minutes or records must be on the record for the record, as well as the decision order must be on record, signed and sealed by the clerk. So I proposed that motion, and like I said, support the affidavit, as well as I motioned for a copy of the actual transcripts, a copy of the so-called argument between parties, based off the minutes and recordings that was filed for the record, as well as his decision and his order that was supposed to be on the record for the record, i.e. minutes and the records signed by the clerk. Guess what? He ain't got that, because he gave me his order in silent. He didn't come out and say his order. He just gave it to me in silent because he cut the record off. So now he can't support his decisions in order, which rendered his order invalid. Why? Because there's no record of it. That's a violation of law.
Dismissed.
Dismissed. Two, in lieu of his order being not signed and sealed by the clerk, having the raised seal, I wrote a motion to the court. So now the clerk's telling me that the warrant, after the judge issue a judgment of possession, a warrant of removal can still be issued out to the so-called officer of the clerk to be issued out to the so-called tenant. But how can they do that when there's a motion on the court to stay the warrant of removal in lieu of a decision that was rendered without a signature and seal, supported by a record on the record, but they don't have that. So the clerk tell me that they can still move it. So I received warrant of removal in the mail the other day. This is it right here.
Let's show that. This is the original copy of the warrant that was issued out by some court officer.
Her name, the court officer name is John Allen. Wallen, right there.
Which it wasn't even valid because it's missing the signature right there before the top. See that? It's missing the signature. So, family, what I was trying to show y'all in other videos, in my other videos, when they keep giving these orders, this is factual proof right here. You gotta start doing your own audit by looking at these orders. And when it's missing signatures like this right here, we're showing you. You see where it states signature? It's missing the signature, family, and we got it dismissed. It's missing a signature. So this writ, which you call writ of removal, it's invalid.
Invalid.
So it's just that no one's challenging the validity of warrants, i.e. orders. But we are. So we challenged it, and Grand Sheik, show them
the results.
Show them not the results first, but show them what you filed.
Oh, yes.
Pull up what you filed to the court.
This is what I filed. Before I do that, I want to show you the Notice of Eviction Act to show you that what you see here is not what's supposed to be done. Let's go ahead.
He finding it right now, family. We gotta be on this type of stuff right here. Don't say it can't be done, because it can be done. We're proving it and we're showing it. I already got videos out there that's showing it. We just not looking at this stuff. It can be done.
It says New Jersey Department of Community Affairs, Division of Codes and Standards. You see, it's a landlord/tenant informative act, information act. It didn't say landlord and tenant. It said landlord/tenant. They're one and the same.
They're one and the same, family. Do you hear that?
One and the same. They just transfer you as the tenant. They become the landlord.
Correct. You are the landlord. Ain't that something? It's people, boy, a lot of people are ignorant to this. They don't even know this.
Look up New Jersey Revised Statute 46 2C. Hold up now. What is it? New Jersey Revised Statute.
I wish we had.
No, you got it. New Jersey Revised Statute 12A 1-203.
Correct.
Look it up.
Correct.
It tells you that the tenant is responsible for taxes, registration,
utilities, everything.
But you don't pay for that, do you? You pay a flat rate. That's the rent.
Which is a tax.
That's a tax too. But you don't pay all the other stuff. So that means that the landlord is supposed to be paying that.
Correct.
Now, in order to understand that, you must look up gross lease and net lease. Under gross lease, it says that the landlord pays for everything and the tenant pays a flat rate. On the net lease, it says the landlord pays for everything. So that means that the landlord is supposed to be really paying for everything, but they not practicing under net lease. They're practicing under gross lease, which means that they created you as a tenant and only you pay the fee.
Correct. They switch statuses up because that's what people just still don't understand. It's about status. They switching status.
Exactly.
They making you the tenant, and he just stole your status as the landlord.
Exactly.
The real true overlord of the property.
Exactly.
The real true owner of the property.
Exactly.
They switching your status, and that's what brothers, that's what the family don't understand. And that's why the Grand Sheik is annotating this to y'all, that he's not only speaking it, but he's walking it as well, and showing proof that this can be done.
Islam. And in lieu of that, it's important to understand that the legal fixings will get you in trouble. You have to be, you are the creditor of the legal fiction. You have the rights. All the debt was created by that debtor. You, as the creditor, have the right to all the remedies, security, interest pertaining to the debt created by that. So as a creditor, you have the right of subrogation to discharge that debt. Because as a right of subrogation, it's going to be collected by two ways. What? By way of tax write-off or by way of insurance. So now this is how they do it, by tax write-off, because they list you as an employee.
Mm-hmm.
As an employee,
it lock you in as the debtor, i.e. borrower, knowing you the creditor, i.e. lender, the one who created the credit.
Exactly.
They criminals, man.
Because if the actual goods, i.e. property, is used for dwelling, they can't tax it. But used as a business, they can tax it.
Yeah, yeah, correct. You know correct. If you're operating as in commerce, they can tax you. Because that's something that they operate.
Okay, let's go back to that warrant of removal. As you showed you that it didn't have a signature. So this is the Notice of Eviction Act, which is governed by New Jersey statute, annotated statute 2A 42-10, 15 through 17. But the actual call I'm looking for is in 16. It says it right here. At the time of a warrant for possession is lawfully executed, the court officer involved shall prepare a statement, i.e. affidavit, of execution of warrant for possession, and shall immediately deliver the statement to the landlord or the landlord's representative by personal mail. It should be distributed by certified mail, not personal mail, because you can't prove that you received it. They send it to you personal mail, so that way they can roll right over you. Certified mail receipt, according to the Fourth Amendment, is a proper way of service. It says that the court officer shall deliver a copy of the statement to the tenant by personal service. However, if it cannot be personally served, it may be delivered in the manner provided under New Jersey Revised Statute, New Jersey Statute 218-54. The statement shall also be affixed to the door to the unit to which the warrant applies. The statement shall identify the warrant, the date of issuance of the warrant, the court and judge who issued the warrant, the date and time of execution of the warrant, the name, signature, and position of the person executing the warrant. Pay close attention to this part right here. The Superior Court Law Division Special Civil Part shall be in jurisdiction for a period of 10 days subsequent to the actual executive of the warrant for possession for the purpose of hearing applications by the tenant for lawful relief. So now if something was executed unlawfully, i.e. warrant of recovery, by a court officer, which unlawfully did, which we just proved, because it didn't have no signature, didn't have no seal, didn't have no statement, i.e. affidavit, didn't have no date that it was served. Let's go back to it.
It had no time, no date, nothing. No time,
no date. Let's go back to it.
No signature, no raisin ball seal, nothing.
There's no signature. Date executed, you don't see it. Date posted, you don't see it. They executed warrant served on landlord, you don't see it. Served, why you don't see it? Warrant served on tenant, don't see it. Charge for execution, whatever that is. Local service performed, none of that's filled out. And according to that statute you just read, according to the Notice of Eviction Act, it must be done. The last paragraph you just read, that the Superior Court attains jurisdiction in lieu of an application by way of a tenant in lieu of relief for something that was improperly served. So let's get into that more. Okay, so in lieu of this warrant, I went down to the clerk and filed a certificate of relief in lieu of the so-called warrant removal, in lieu of these 4 points. 1, they was paid. I wrote a check out to the Department of Treasury on behalf of on the instructions of George Courtman. Because once he came out of his chambers, he said, just write a check out to the Department of Treasury. And that's what they do.
That's what he said. Write it out to the Treasury Department. And that's the remedy he gave us.
He gave it. So I did exactly what he did. So the first thing, let's read it for myself. Read it for you. Check it out, Morris. There you go. And also, Morris, make sure you get your seals and stamps made up. It's important to reserve your substantive and inalienable rights so that it will be on the record on their documents. As you can see, you see the Morse code.
Y'all see the seal right there, family? It say without prejudice, without. I've showed y'all this already on on the videos. I have showed y'all this before, how I created mine. So the Grand Sheik got his right here as well. Without prejudice, without the United States Corporation, a natural person pursuant to New Jersey Assembly Bill 3823, New Jersey Statute 14.8:2-1. All natural rights explicitly reserved, all constitutional rights reserved. Right there, and the codes.
And the code, and that code 667 is the code for Moors, i.e. birds.
Correct.
All right. As you can see here, Title 49 Code Section 72, 101, and 102 deals with their constitutional oath. So now this is an order. You put that there. For them to create an order in violation of their oath puts them in trouble. That's why you put that there, so they think twice about ruling against you or doing something unlawfully when you got that code that obligates them to their law they say they do, as well as without prejudice pursuant to UCC 1-207 and 1-103.6. So now let's get into the meat. This is Superior Court, New Jersey, Law Division, P.O. Box, received by landlord, Woodhaven Terrace, plaintiff, Clifford, Jefferson, L. Bay. It says, now look at how I addressed it. Care of 79 Moody Drive, Building 10, Old Bridge Territory, exempt postal zone, Belwick of Jersey, England.
You see that, family? Do you see that?
You can see it. They didn't say no, we don't accept that. They accepted it.
He put Belwick of Jersey, England. We are in England still.
There you go. All
New
right.
Jersey Republic.
This was actually initiated on, he said, my lockout date was 12/14/18. What's today's date?
15.
It's the 15th. You see me locked out? No. It says here, as of today, how much do you owe? You see that? It says 0. Why I don't owe? Because on instructions from Judge Corman, I paid by check to the Department of Treasury for Woodhaven Terrace. Judge Corman has a copy of the check in my file, as well as I have several motions supported by affidavit on the record, 2 to vacate complaint, 2 motions for default for failure to respond to answer and counterclaim, and motion to vacate order of judgment of possession because of no clerk's signature or seal, as well as the warrant of removal had no signature or signature of the officer or seal or affidavit to support it. You should hear that. So
you hear that, family?
Wrote that out, went to the clerk, as well as I filed a motion for criminal assimilation by the officer, as well as the clerk of Superior Court, Michelle Smith, because that's criminal assimilation, to act as something to be done that was not something as lawfully done when it actually is not lawful.
It never took place. It never happened.
Took place. And apparently, watch what the judge said.
This was the judge filed. December 11th.
You read it for me, brother.
Now look, this is December 15th. He filed this on December 11th, 2018, when we stood before the court, when we went to court. Here it is right here.
Superior Court, New Jersey. Law Division, Essex County Special Civil Part, LT 9317-18. Order. It says, Woodhaven Terrace, LLC, plaintiff's landlord versus Clifford, Jefferson, L. Bay, defendant tenant. Did you see my name in all caps, more?
It ain't in all caps. You see this status. See why status is so very important? Ain't nothing in all caps.
This is tenant, name, Clifford Jefferson. Tenant address, 79 Moody Drive, Old Bridge, New Jersey. Now, of course, they ain't going to say England because they know that they were accepting what
Correct.
right
Correct. That's a cool, automatic disqualification.
So they got to protect themselves.
Of course.
But look at what he said.
Because they're a corporation. That's automatic. They'd be like, you're fired. Get out of here.
Okay. Now, look. The judgment of possession was issued by the same judge. But remember, he did it off the record.
Correct.
There was no minutes. There was a recording. As well as he did it by way of handing a piece of paper. So I filed a motion of judgment, order to vacate the judgment of possession because there was no signature of the clerk, nor seal.
Nor affidavit.
No affidavit to support it. So once I did that, I also filed a motion of the transcripts. So now When I filed the certificate of relief, which we just read, I mentioned that they were paid. I also mentioned that I got these motions on the record in lieu of the defendants being in default, as well as your order for the judgment of possession didn't have a sale by the clerk, nor affidavit, nor engraved sale, nor did the warrant of removal sent out by the court officer issued out by the clerk, Mr. Smith, didn't have a sale, nor was it a statement by affidavit, nor was there no signature. This is what he wrote. A judgment for possession having been entered in favor of the plaintiff landlord. An application having been made to the court by defendant tenant, and it's appearing from the attached certification that a stay of warrant for removal is appropriate.
It's appropriate.
You hear that? They say it's appropriate. And it's on this day, the 11th day of December 2018, is ordered that the execution of the warrant of removal is stayed until all pending motions have been resolved.
Resolved. So they gotta hear us regardless on all the documents that's filed in the courtroom in lieu of the Grand Sheik's status, and he stated over the record he's the landlord.
Exactly.
And he is. And not only just that, for the record, we already got the attorneys on behalf of the plaintiff, which I like to know who that is, because again, the Woodhaven Terrace is a corporation. Exactly. There's no flesh and blood man that's coming in that's going to hold that up.
Exactly.
They can't validate or verify that. Mm-hmm. Where he at? Where's the landlord? We are the landlords.
Exactly.
They switch places with you.
Mm-hmm.
And we got this beat. Furthermore, we got it beat because they've been defaulted twice. There's no more moves now. We got it beat.
And what makes it so bad is that the certificate of relief in lieu of his order was to vacate his judgment of possession in lieu of this warrant I just showed you. He granted it.
He granted it in favor
of me,
of the defendant.
So that means if his order of judgment in lieu of the warrant was right, he would dismiss this. Say no, you're not getting.
He just disqualified himself any other time, on all the rest of those motions that's filed before the court.
He disqualified.
He just disqualified himself.
So he got a rule in my favor. You know what he did? He put the blame on the plaintiff.
Oh, he has to in order to protect himself.
He ain't going to jail. He ain't going to hang himself. Y'all got to answer for this. Y'all in default.
Correct.
If you don't answer for this man, you better give him what he wants. You know what I filed for? Acquired ejectment. It's 68-2C-1. This means acquired ejectment means that you have to write to file a counterclaim in lieu of somebody assuming to have a security interest in property. They don't. They just have possession, not a security interest in it. Why? Because they were granted possession by way of under what they call title of nobility.
Correct. A certificate.
No title of nobility.
He can't transfer. He can't transfer our heirship, our status, our allodial to no corporation.
Yes, because I clearly stated that the statutes of Westminster of 1285 clearly said that it only supposed to transfer to the heirs.
To the heirs.
To the heirs. So now, Moors, I have proven without a doubt that I am an English noble Anglo-Saxon Berber from the house of Geoffery that go all the way back to the time of who? Andakabi, which was the time of Julius Caesar, which goes out even further to that of Sheik I, whose particular tribe was called the Bubasite tribe, which is known as Bass. This is why you see the cat on everything. Look up the movie V for Vendetta. When they hung my man, you'll see that flag of plantation on it. The V means 5. What's happening now in London right now is what's happening back in that movie. Why? Because Geoffery V blew up the House of Parliament. That's called Moulton Bailey. There were castles. I got one more thing I want to show you guys. To show you that we're Jews. It's about to blow your minds, Moors.
This is a beautiful thing right here. Moors, you better start exercising this right to the land and property. I don't care even if you renting. I'm telling you, stand on proper status, and I bet you'll be able to get the property. We got a major counterclaim in. They know we pushing hard on it, and we gonna win this.
Yes, sir.
We got it beat already.
Yes, sir. It's already beat.
It's already beat. We already got it beat. They already disqualified themselves.
We're revoking charters.
We revoking charters.
We're revoking their charter. My counterclaim is to have them revoke their charter and remove them off the land by way of a missing heir.
We gonna get this land. Yes, sir.
Look it up. Quiet ejectment. In lieu of a missing heir. Meaning that my surname, Geoffery, supports the fact that I'm a descendant of an English national. This is why Noble Ali said, don't throw away your slave name, i.e. English name. They're a part of your birthright.
So this is the proper way you claim this land.
Exactly.
See, the brothers ain't doing it like this.